With that funding question, I want to move to Tony. So Tony, in investor world, we are hearing that investors love patent. I mean, they just love it. What's the reason for loving patent so much?
Okay, well, it's a little complicated. I mean, a lot of small companies, a lot of individual inventors, for instance, uh, think that a patent gives them to the right to market a product or gives them the right to sell a product. And unfortunately, that's not the case. What a patent does is it allows you to exclude others. Now, that seems like perhaps a bit of semantics, but from a business perspective, that is a critical difference. Uh, if I had the right to sell something, then that would be a little bit different than the right to exclude, because with the right to exclude, I have to enforce my right. I have to go to a jurisdiction and I have to say, look, I have a patent here. These people are infringing it. You need to stop them. And then you go through a relatively involved process of identifying that they are in fact infringing and that they are in fact doing damage to you. Meanwhile, you're highly likely to end up in a legal proceeding of your own, whereby they're challenging the validity of the document in the first place, the idea that you should not have been granted a patent. And so I'm a big fan of patents. I see them being used all the time. I think it's foolish to have a technology company that isn't protected by patents. But at the same time, you have to go into it with open eyes, in the sense that you have to recognize that if you're not willing to invest what is easily $500,000 and likely considerably more, and you're actually going to go to the trouble of enforcing the patent, well, then you've cut off the primary right to exclude. Now, the patents can still be valuable because they're, of course, a bargaining chip. They're a means by which you can license to others. They're a means by which you can cooperate with others and have something, I refer to it sometimes as table stakes. The idea that in a
Yes.
poker game, you've got to bring a certain amount of money to the table in order to be able to play. In a technology field, a lot of times patents are those table stakes. If you don't have any patents, you're really at the whim of everybody else that can threaten you, that can exclude you, that can charge you higher licensing fees. There's all sorts of different things that organizations can do if you're not on an even playing field as such with regards to patents. So I would say that for small organizations, SME, small medium enterprise, individual inventors, just and make sure that you've got a good solid idea of how it is that you think these patents are going to actually help you meet your business goals. A patent attorney is a little bit like a surgeon. If you go to a surgeon and say, yeah, I've got a headache, he's going to say, well, okay, I can slot you in next week. We'll open you up. We'll take a look, and then I'll let you know what's going on. Meanwhile, a different doctor would simply say, take 2 aspirin, call me in the morning, let me know if it still hurts. And a patent attorney is going to say, sure, I can get you a patent. But he may not be what you really need. And so you want to be really careful about understanding exactly what it is that you hope to accomplish and where it is that you hope to move to as your business grows. And those are some of the key things that you're going to want to look at when deciding what your patent strategy is going to be.
Can I pipe in here for a minute? The Worldwide Development Corporation, that's why we're seeking a country like the central government of India or somebody like that, because these patents that will be submitted are so important to the world. So you have to try to find partners that match up with what you've invented. If it's something extremely important, you're going to need very large partners to protect those patents. And that's exactly what the Worldwide Development Corporation is facing today. Otherwise, companies will just patent something 99% the same as you, and then you need to fight them in court, which is extremely impossible for a small company to do. And if, like for me, I'm trying to protect these patents so the royalties go to poor people in the middle class around the world instead of the few that, instead of a large company that just overtrumps me, are a bunch of large companies that do. So exactly what Tony is talking about is the Worldwide Development Corporation's problem that we're facing.
There's just one thing that I'll add to what John said. You have to be very careful. There's something out there called an on sale bar, and an on sale bar, and there's also a disclosure clause that once certain things are talked about publicly about inventions, in most countries, they're no longer patentable. So I'm not a patent attorney. I don't give legal advice, but I would be inclined to share, just for sake of goodwill, that provisional patent applications are generally a very, very good thing because they allow small companies to file inventions, get some form of, they can stake a claim. They can say on this date, we had this particular invention, we had it filed, and then they can even do a slow roll where they take their time in deciding how quickly it gets reviewed, examined, until they've lined up funding, they've got prototypes and so on and so forth. But it's really critical that you get something in front of a patent office as quickly as possible, because otherwise, if you get too far down the road, you're going to get sued, and someone's going to say, "Well, you can't patent that because you disclosed it already. This wasn't an invention. It was something you already talked about with others." So just as an FYI, something to think about. And
the problem with that, Tony, is that the patent systems around the world and even within countries are corrupt. And so if you file even a provisional patent, more than likely, there's what they call patent moles, which I'm sure you're well aware of, that's all they do is search for patents. And so then that would not protect you at all, because then another company would just jump ahead of you and file the patent. So, there's problems either way. And I understood what you just said, and we looked at that and decided to wait.
Yeah. Patents take 18 months to publish. During that time, they're considered secret, and it would be against the law for a patent office to disclose.
That's like an outrageous claim. I mean, of course, it's not possible. As a patent attorney myself,
but I've never heard of an example of somebody got something stolen before it was published. That somebody came into the patent office and took a file and went off. Not to mention the fact you can ask that it not be published at all in certain countries, in certain circumstances. So, anywho, I'm sure you're talking to legal counsel, John. I'm sure your counsel is giving you great advice, and so I'm sure it'll work out really well.
I don't know if it will or not. We're hoping.
No worries, John. You will find right one.